Hello, I'm here with Ed Pohl of LawBiz, and Ed is a multifaceted individual. Ed's been a business person, a lawyer, and now a law firm coach. And Ed's on his Road to Revenue tour all across the United States this summer, and he's taking some time out to spend some time with us here in Wisconsin. And welcome, Ed. Thanks for coming.
You. My pleasure.
You know, you've been around a while. You've seen a lot of ups and downs in the legal industry. And you know, today when you were talking, you really were focusing on, you know, collecting the fee, getting your fee paid, so you can keep your office doors open and have a life and enjoy it. If you had to identify 3 best practices to prevent fee collection issues, what would they be?
Well, as I said in my book, Collecting Your Fee, Getting Paid from Intake to Invoice, which is published by the American Bar Association, my approach is a little bit different, because the approach that most people take is, okay, you've done the work and you want to get paid. Now let's, steam ahead and file a lawsuit or whatever we have to do to get paid. And I think that the real issue of getting paid is determined based on the initial intake, the initial conversation you have with your client. I think that if you approach that conversation appropriately, that you can tell then, and then I've said, I'd even be willing to make a bet. You let me be the fly on the wall, and I will bet you I can predict with a high degree of accuracy who will pay the bill and who will not pay the bill, based on that initial conversation. And unlike most people who think it's the client's fault, I think it's the lawyer's fault that they're not getting paid. And if you take a look at the initial intake, what kind of conversation did the lawyer have with the client? Did they have a written fee agreement? Did they highlight a conversation with the client about what the fee would be and what the likely overall cost would be? The per hour cost is not of importance to the client. We all focus on that. But what they really want to know is what's going to be the overall cost of the legal service to address the issue that they've raised. So number 1 is the intake conversation. Number 2 is a written fee agreement. And in almost all cases, I know Wisconsin as well as other jurisdictions have the limitation of $1,000. Anything above, you have to have a fee agreement and so forth. But I think that in that fee agreement, there's a paragraph. The paragraph talks about what your rate is and what the overall fee will be. And I think it's a mistake for the lawyer not to say to the client, hey, Nerino, this is a written agreement we're signing. It's a contract. Now, contract in legal terms requires 2 people. You as the buyer, me as the seller. I have certain responsibilities I have to provide you. But you also have some responsibilities. You have to tell me the truth, you have to provide me the information, and you have to pay my bill. And so in that fee agreement, you have to highlight to the client that it's a 2-way street. On a telephone conversation, I can call you, right? But when I call you, what do you have to do? You have to have a like receiver on your end to hear me and to answer me. And that's what you've got to highlight to the client. So I think those are 2 or 3 of the responsibilities and the highlights for me that will enable you to get paid.
It is amazing. I mean, I've noticed that just in the years I've been out practicing and here in Wisconsin, lawyers can be the most zealous advocates in the world, but you put them across the table from a potential client or a client, and they become meek when it comes time to talk about fees. So I think that's some very good points that you bring up. Assuming that even in those situations, there may be times when lawyers aren't able to collect their fees, or are there common traps that you've seen as you've gone out and coached lawyers that attorneys face when they go to collect their fees?
Well, one of the traps is the failure of law schools to teach lawyers how to run a business. And their perception is that if you want to learn how to run a business, you go to business school. And that's well and good, but there is something a little bit different about a law practice. And law schools, I think, fail to address those issues. Another trap is that we think that we're a profession. And therefore, because we're professionals, we have nothing to do with business. And because we have nothing to do with business, we don't run our law practice like a professional service business should be run, like an accountant runs, or a doctor, or an architect, anybody else that might run a business. It is a business. It's a service business, and we have to approach it that way. And the problem that lawyers fail to understand is that if we don't take care of ourselves, our clients have little respect for us, and they're unlikely to refer other people to us, though we have performed great legal services. And I think that that's a major trap. Another trap is that we're hounded by insurance companies not to file a lawsuit. The reality is that anywhere from, depending on which statistics you want to believe, anywhere from 1% to 15% max of people file a cross complaint or a counterclaim for negligence when we file a complaint to get paid when the client fails to do so. So I think in the insurance companies, in my perspective, don't want us to file a lawsuit because it's going to cost them money. They're going to have to pay a lawyer or whatever. And so I think it's a real problem. We do it to ourselves. Our clients aren't doing it to us. And I think that if we put all those issues aside and we look at the file, we do our own peer review, or we bring somebody else in as a peer to review our file to make sure our file is appropriate, is absent of any potential negligence, then it's up to us to decide whether to write it off or not write it off. And I would encourage you not to write it off. But also, in my opinion, your first loss is your best loss. If you understand the flow of your work, if you understand that the client has stopped paying you or has never paid you, then that's the time to make the decision. Not down the road, months or years after you've done the services, but right away.
What we're seeing today, especially in this economy, is there are a lot of lawyers that are going out from law school and they're hanging their shingle right out of school. I mean, that's something that 15 years ago was just really not done or not spoken about. So we've got a lot of inexperienced lawyers out there. I mean, they're trying to learn not only the practice of law, but the business of law and how to make a living. If you could give that inexperienced lawyer one piece of advice on how to collect their fee, what would it be?
I think that the best advice one could have, if you don't have a lot of experience and just don't intuitively know which is the right way to go, is to have the conversation with the client and ask the client, what is this service worth to you? And to price your service more in line with what their value perception is. Because if you can deliver your service in line with their value prescription, their value understanding, it's highly unlikely you're ever going to have a problem collecting your fee.
You're just one person, so you travel a lot. You're out airstreaming this summer with your lovely wife, and are out on the road. But if people would like to find out more about you and about the books and things you've written, where can they go?
Well, you can call me directly at 800-837-5880. They can go to my website at www.lawbiz.com. They can send me an email, edpoll, EDPOLL, @lawbiz.com.
Ed, thanks a lot, and I hope you have a great rest of the summer.
Thank you, Nerino. It's been a pleasure to be here.